I'm going to address my comments now to two different things. First, powers of local governments, powers that local governments do have with respect to gas drilling. And then I'm going to spend more time on what's called the takings threat. I think one of the reasons I feel that we are moving in a successful direction of banning this kind of gas drilling is that the people supporting gas drilling have, and the lawyers and various spokespeople have begun to make this threat that, well, if you ban gas drilling, then that is a taking of my property, and you can't do that. And remember, when a lawyer says you can't do that, you have to take that with a grain of salt. But we're hearing more and more about, even among some people who are supposedly in agreement with us, oh, well, you can't have a ban because then there's going to be all these lawsuits that we're taking property. So it's a sign of our success that those arguments are being made. There's a real possible banning of gas, and so they're rolling out the next argument. Okay, but so first, though, I do want to address the powers of local government, and let me say I've already done a presentation on this that's about an hour long, and I don't have that kind of time, and I think that some of the information about it has been disseminating out to the public. But you can actually watch a much more detailed presentation on this by me if you go to essentialdissent.com, or anyway, just Google Essential Dissent, and I made a presentation on January 27th this year in Norwich that is a lot more detailed. When I first started becoming aware of the potential problems of gas drilling, there was a sense, there was some trainings, particularly for like local municipal officials, which I was, from people in Colorado and Wyoming who said, well, you can't ban it, but try to get organized, get your ducks in order, try to get to negotiate some mitigations, do the best you can. And they sort of warned us of the problems and sort of had the more negotiating strategy, get mitigation, stuff like that. And of course, the municipal governments were told, well, there's nothing you can do. And the one thing that they allow us to do, supposedly, is there's in the Environmental Conservation Law, Section 2303- subsection 2, a provision that says the Department of Environmental Conservation shall regulate gas drilling, but local governments shall retain their powers to control over their roads. And then there's a little provision about taxes, which I'm not really going to cover today because there's not much we can do. There's not much going on in that area. So that was sort of the one little tidbit they held out to those of us in local government. Well, you do have the power to regulate your roads. In my little town of Afton, we eventually started looking into having a road protection law. We eventually did pass one by a vote of 3-2 after about 4 versions, with all kinds of arguments being brought out by anti-gassers, and we came up with responses. We amended, we tweaked, we tried to deal with the concerns, and yet really the purpose was not to ban or claim broader rights. It was just to claim a right that even the government acknowledged we had, which is to control our roads in a way that made sure that the taxpayers weren't paying for any destruction to our roads. It was also a way of educating our local people about the impacts, because literally some of the initial arguments were, oh, you know, all those heavy trucks will actually compact the road and make them better. Okay? That was the level of consciousness. Eventually, enough people went down to Pennsylvania or read the papers, and so it was an educational process. And that has continued. And some of you who are real local may know there's all kinds of activities still. We did eventually pass a law. It was a kind of concentrated heavy traffic. We tried to stay within the kind of legal parameters that they allow us. And right now we're in the position of having been informed, and I think under sort of legal precedent, that we needed to do an environmental assessment form and a determination before passing the law. And so we've had to kind of step back and are now in the process of trying to comply with that, you know, crossing the T's and dotting the I's so that we can pass the law, but meanwhile, land coalition groups have started attending our meetings en masse, and in response to that, local people have started attending our town board meetings en masse. And so we're, it's like there was a little bit of kindling under, that has started a more open flame of anger and intensity that is daunting, but in some ways very encouraging. People are beginning to understand that how serious this is, and you all have been understanding that for a long time, but that's not always the case in our little towns, where a lot of people don't read the newspaper, or if they do, the newspaper accounts are biased, or they talk to the kind of established economic powers and interests in the town who have either made or expect to make money from gas drilling. So I'm not going to really address much more than that. It's just a little baby step in claiming some rights that we should have over our own local community health and governance. There have been much more ambitious responses on the parts of some other local communities, such as over near Otsego Lake in the Cooperstown area, as well as in the town of Ulysses, for example, in Tompkins County, and in Sullivan County. I don't remember the towns, but Carol Roig, where? Highland, yes. In fact, actually, I guess there's 3 towns that to some extent are working together, but Highland in particular, where they've consulted with lawyers who have looked at this preemption language, and we don't call it Dillon's rule in New York. That must be a Pennsylvania term. But again, there was this environmental conservation law, this statute in New York, which says the DEC has sole authority to regulate gas drilling. I'm shortening it, of course, it's oil, gas, and solution mining. To regulate gas drilling, but towns still have authority over roads, local roads. And so while supporters of this kind of gas drilling say, well, that preempts communities from engaging in zoning or any kind of a determination of the use of their land, lawyers have done the research and are being advocates for their clients. And at first there seemed to be, oh, you had no rights. And then I think the earliest argument that no, we still have, even under current law, the right through zoning to regulate our land, not regulate gas drilling, but our land, came out of an article in the New York Zoning Law and Practice Report of January and February of last year. So just a little over a year ago. And it set out the argument that while local governments under this statute don't have the authority to regulate gas drilling, it doesn't take away their right to regulate through zoning laws their land use. That's what zoning generally does. And several people have crafted very good laws in New York State, in Ulysses and all that, and I would specifically point out that Helen and David Slotgy at the Community Environmental Defense Council have worked very hard and crafted very, very good model laws and memos to support it, to show that, in fact, there is good legal precedent through similar interpretations of similar worded statutes, like the Mined Land Reclamation Law, in which the highest courts in the state of New York have said, well, yes, while a community can't regulate gas drilling, and by that you think of things of the quality of the concrete in the casing, or the width of the casing, or the actual regulation of the gas drilling, but that the courts go on to say they can. That doesn't mean that communities have had their right to control land use through zoning. That has not been taken away just because of that preemption language in the environmental conservation law. It's a fairly, it's a sophisticated, detailed argument. It helps to have a kind of a prior history of the community having, for example, a comprehensive plan in which the community says we value our rural community, and they communities that don't want high impact industry coming into their towns. And so when in situations where communities have done comprehensive plans that, or are now doing comprehensive plans that lay out their vision for the use of their community land, there are very strong arguments. Those cases haven't been litigated yet, but municipalities that are passing those laws have certainly really strong arguments. And so that's how we then get into the, in fact, let me back up though a little bit and say, because Ben mentioned New York is a home rule state, and that is the case. It's at Article 9 of the New York Constitution, and basically it provides, it provides broad authority to enact laws, for local governments to enact laws on property, affairs, government, and for the protection of order, conduct, safety, health, and the well-being of persons and property. And this last section that I was quoting from it, for the protection, order, conduct, safety, health, and well-being of persons and property, is often referred to as the police power. And I wanted to make that clear because, most of us think of police as, well, they're the guys gals who can come and charge you with crimes and arrest you. But the term police power in sort of legal jargon has a much broader meaning, which is that governments, local governments, have the right to protect the safety, health, and welfare of the people and the property in their community. So that's arguably a very strong right, and in fact the cases that have been brought forward and talked about in terms of supporting the idea of local communities being able to regulate land use, if not regulate gas drilling, that they be read as not conflicting with each other, and being given broad and liberal interpretations because of the language in that home rule part of our Constitution as well as a local statute. Okay. Now, so there's a lot more detail, and the Slotchys in their with Community Environmental Defense Council have a lot more detailed arguments, and you can, and I at least refer to them in my presentation. And we will be actually putting on, I guess, a Google site certain documents after the conference, and I am in the process, with some help, of editing my oral presentation back in January into some sort of written document, and that'll go up on that Google site for people to look at if that's helpful. So now I want to switch to this takings argument. And as I mentioned earlier, I think that argument is being brought up more and more because it's a sign of our success. When they start talking about, well, if you win, you know, we're going to sue you, is really a sign of making some progress with the public's opinions, and the sort of frame of what's acceptable to talk about is being expanded to include ban. I mean, I remember people saying, oh, you can't talk about a ban. And that's no longer the case. People are talking about a ban. So, but there's concern. Oh, you know, again, because lawyers will say, we're going to sue you, or people say, their lawyers say, we're going to sue you, and there's a concern. Money's tight. So I want to explain what this whole takings argument is, and again, I'm not going to go through a lot of cases. That's going to get written up and put on that Google site too. But the basic argument is that the Fifth Amendment of the United States Constitution provides certain protections, and it's part of the Bill of Rights. And the Fifth Amendment lists a bunch of them. There's double jeopardy, the right to, you can't be forced to testify against yourself. And then it goes to, it says, and persons can't be deprived of life, liberty, or property without due process of law, and here's the key, nor shall private property be taken for public use without just compensation. I'll repeat that. Nor shall private property be taken for public use without just compensation. So the word taken in there is the takings that people refer to when they say the takings clause. You can't take private property, the government, that is, can't take private property without just, you know, giving just compensation. And that was, you know, it was an important right, because the government before that did that, took it and didn't compensate. And generally that's been talked about as eminent domain, and that's I mean, there's historical evidence to suggest that the original intent of the takings clause was meant to just be the physical appropriation of land. So we're thinking eminent domain, you know, we're taking this land because we're going to build a public school here, or we're going to build a public park, or we're going to build a road or something, a public use and a physical appropriation of land. Although it could also, in that context, include personal property. The government's going to take your horse or your mule or whatever. So that's what the takings clause used to refer to. But what if the government, say through a town zoning law or a state law banning gas drilling, without taking title to any property, where gas companies and gas lease holders are expecting to drill for gas? That is, what happens if you restrict the use of the land or the profit-making opportunity without actually physically taking the land? And there are cases, of course, talking about this. I hear, it's really in the, I hear the concept from various people of, well, I can do anything I want with my property. I'm sure you have all heard people tell you that I ought to be able, I've heard people say the Constitution gives me a right to do anything I want with my property. And that's not really the case. The U.S. Supreme Court has said, as early as 1887, that all, and this is a quote, all property in this country is held under the implied obligation that the owner's use of it shall not be injurious to the community. 1887, and they actually haven't ever had the nerve to say it differently. Okay, so the Supreme Court has and here use the word, created a muddled area of law with regard to takings, because as you do the research, there are inconsistent decisions. For example, in 1922, the Supreme Court held that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. And that, interestingly enough, was a Pennsylvania case where the subsurface owners, coal mining companies, were digging out so much coal that the surface owners' land was subsiding. And yet, when Pennsylvania tried to protect themselves, you know, the surface owner, the Supreme Court said, no, that's a taking. And yet, in 1987, an almost identical statute in Pennsylvania held the opposite. Luckily, sometimes it's good that the Supreme Court is willing to state a different principle. So the more recent principle is, you know, said that that was not a taking, which the government had to pay the owner of that subsurface right for. So you can see there's inconsistent decisions. And I won't go through lots of cases because there's limited time. One of the most major ones that did encourage the not just gas drilling people, but large corporations who were trying to resist, who wanted to take profit-making opportunities by exploiting land, is a case called Lucas versus South Carolina Coastal Council. And that, in that case, Justice Scalia, you can almost always tell a case by the outcome by who the judge is, remember my principle, said that a preventing of a particular profit-making opportunity would be a taking where it was a total taking. There had been a judicial finding that this guy's coastal land that he wanted to develop into a resort, the South Carolina had prohibited him from doing that, even though he had owned the land before. And so he said, well, you know, you can do that, but you got to pay me my lost profit. And there had been a judicial lower court finding that, in fact, this prevention of the right to develop the land had rendered his property to be of zero value. Zero value. And in that particular circumstance, it's like a physical appropriation the way eminent domain is, the taking of the land for the public school or whatever. And so Justice Scalia kind of carved out this exception of if it's for public benefit generally, you don't have the right to compensation, but if the taking is total, then you should get compensated. So, you know, and then there's after that, there's cases that seem to go the other way. And to summarize, to make a takings argument, the following conditions have to apply. A taking claim by, you know, pro-gas people cannot be based on an interest that the owner never had. And that, so when you, there's all kinds of statements throughout all of the takings cases that the, you can't, it's not a taking if what you're doing is trying to exploit your land and it's affecting other people. You never had the right when you own property to create a nuisance or a problem for your neighbor, okay? So you don't have a right to do that. You never had that as part of your property right. It's, you know, that concept of all property is held under the implied obligation that the owner's use of it shall not be injurious to the community. That you don't have the property right to injure your neighbor's community. That's one. Number two, a taking claim does not apply if the property can be used for other purposes. So there was a judicial finding in this Lucas versus South Carolina case that it was worth zero. But if you can show that the property has any other value or purpose, and almost all of the cases find that there is still economic value, it's just that it hasn't been totally extinguished. You can, it may be reduced in value, but the mere diminution of value of property however serious, unless it's total, is insufficient to be a taking, okay? So, you know, there's a gravel pit, there's a case. A gravel pit, the town of Hempstead does a regulation saying you can't dig gravel more than 2 feet above the water level. And the guy who's had the gravel pit since 1927 says, wait a minute, you know, I can't do anything with that piece of land. He lost that case because he still owned the land, he can do other things with the land. He was not able to prove that his land had zero value. It had a lot less value, but it didn't have zero value. And third and final, the burden of proving that a government's law or regulation is unreasonable, that is, that it really couldn't accomplish the goal that it was setting out to claim. If you can prove that that's unreasonable, then you know, you, the one who's claiming it's unreasonable, have to prove that. And in general, courts do give deference to the judgments of legislatures. Of course, you know, that can vary from time to time. So, to end, in a case called Jernat Asphalt Products versus the town of Sardinia, which is a New York Court of Appeals case regarding mineland reclamation, which is a similar statute to the environmental conservation law, the highest court in the state of New York said, a municipality is not obligated to permit the exploitation of any and all natural resources within a town as a permitted use, if limiting that use is a reasonable exercise of its police power, remember I told you what that was, to prevent damage to the rights of others and to promote the interests of the community as a whole. So we have the right to make these claims. We have good precedent to support the fact that these will not be considered takings, and that's just a lot of claiming on the part of the lawyers and the supporters of the financial interests that would like to discourage us from doing these things, but that doesn't mean they're going to win. Okay?